The Bombay High Court on Wednesday directed that comedian Kunal Kamra, booked for cracking an allegedly objectionable joke on Deputy Chief Minister Eknath Shinde during a stand-up comedy show, shall not be arrested till the court passes order on his plea against the FIR. Now let's break down what exactly the court said. The Madras High Court had extended interim protection from arrest to Kamra till April 17. After 4-hour-long arguments, the High Court reserved its order on Kamra's writ plea, which, pending its disposal, has also sought a stay on proceedings arising out of the said FIR by Mumbai Police. Taking cognizance of a complaint filed by Shiv Sena MLA Murji Patel, the MIDC police in Mumbai booked Kamra on March 24 for offences punishable under sections 3531B and 3532 statements conducing to public mischief, along with 3562, that is a defamation of the Bharatiya Nyaya Sanhita. They later transferred the zero FIR to Khar police. A bench of Justices Sarang V. Kotwal and Shriram M. Modak noted that public prosecutor Hiten Venegaonkar for the state government had agreed that summons was issued to the petitioner under section 35(3) of Bharatiya Nagrik Suraksha Sanhita, which specifically refers to the notice where the arrest of a person is not required. It added, and I quote, "In that background, the question of arresting the applicant in this particular case in the respect of FIR by Khar police does not arise. Matter reserved for orders, till then the petitioner shall not be arrested." Senior advocate Navroz Sirvai for Kamra argued that none of the 3 offences mentioned in the FIR were ex facie made out. Therefore, the FIR be quashed, and the pending hearing of the probe, there shall be complete stay on investigation. Sirvai argued, and I quote, "This case exemplifies an attempt by the state at the behest of a political party to make an example of an artist, stand-up comedian, which if permitted will inevitably have the effect of self-censorship and chilling effect." He alleged that the FIR was registered with non-application of mind by the police officers who completely disregarded the procedure of preliminary inquiry before registering the FIR. Sirvai said the FIR was registered with haste and consisted of gross abuse of power by politically motivated members of Shinde-led Shiv Sena, which is part of the present ruling dispensation in the state, and the same was reflected in the vandalism of the studio by certain politically affiliated persons pursuant to uploading of the video. Sirvai argued that the FIR was registered with malified intention, as no such proceedings were initiated by the complainant, despite the present Deputy Chief Minister Ajit Pawar had allegedly referred to Shinde as traitor, and former Chief Minister had made remarks against Shinde during the election campaign. He added that the FIR failed to show any intent by Kamra to cause fear or alarm to the public or harm to public peace or tranquility. This case shows even after 75 years of the Constitution, law enforcement machinery is ignorant about fundamental right to freedom of speech under Article 19(1)(a) or does not care about it, Sirvai claimed. He further said it was almost unprecedented that persons who attended the show and producers of the show were called for questioning, and the same was sheer witch hunt. In his response, P.P. Venegaonkar, while opposing the plea, claimed that FIR was registered as all offences were disclosed. He said as the probe is at a nascent stage, the officers are required to collect corroborative material and evidence to find out the truth in respect of allegations. The state claimed that Kamra's comments in the show were malicious targeting of an individual who is holding the position of Deputy Chief Minister by lowering his reputation and dignity. Venegaonkar said the same was not a humorous criticism or a political satire by any stretch of imagination or opinion on the manner in which the state was functioning. Venegaonkar further argued that the alarm was caused by inducing citizens to vandalize the studio where the show took place, which affected public peace and tranquility, and a separate offence was registered against the same. He claimed that even an individual party comprising lakhs of followers who share common ideology or interest does constitute community under section 353 of BNS, therefore the offence was made out in the case. Venegaonkar said Kamra cannot resort to a defence that he cannot be prosecuted merely because none came forward to register offence in earlier comments made by politicians. Sirvai in his rejoinder opposed the state and said the state cannot say that Kamra was responsible for action of political workers indulging in vandalism. The court asked the police as to what difficulty was in going to Tamil Nadu to record Kamra's statement, as he had cited reasonable excuse of death threats in Mumbai and Maharashtra and instead had sought recording of the statement through video conference mode. The court said it will pass an appropriate order after considering the relevant submissions. For more updates, keep watching the Indian Express.